at Riverhill High School and I take the class Intern Mentor 1 under Miss Mary Jane Sasser. In Intern Mentor, we have to pick a year-long research topic to look up and learn more about. My research topic is case time standards. There were 463 criminal cases tried within the Howard County Circuit Court in 2018, 20 of which went over the case time standard. Case time standards are the amount of time a case should take to be tried and concluded within the courts. Each different type of case has different case time standards. My focus is criminal cases. In the state of Maryland, 98% of criminal cases must be tried within 6 months. The 6 months begins from one of two instances, either the first court appearance by the defendant or the entry of appearance by the defense lawyer. Defendants also have the ability to waive their right to a speedy trial, which does not occur all the time, but it does occur when necessary or as advised by the defense attorney. This 6-month standard is enforced to ensure the defendant's right to a speedy trial as guaranteed by the Constitution and the Maryland Declaration of Rights. These two utmost important documents uphold speedy trial. However, I was wondering if 6 months was too fast and too rapid pace for a criminal case to be tried. I mean, it is somebody's life at stake. So that's where I come in. To gather information to answer my question about whether or not 6 months is a reasonable amount of time to try a criminal case, I interviewed 5 highly esteemed individuals who work within the Maryland judiciary. I interviewed a judge, a court administrator, a public defender, a private defense attorney, and a prosecutor. I first interviewed the judge. I asked 5 questions, however, I think 2 are the most important. My first question was, what factors do you consider when considering granting postponements? The judge told me that they consider any prior postponements and what the reason is, which can be a new attorney, just received reports, further investigation, witness unavailability, etc., how it will affect the trial, or if it is too close to the speedy trial date, and if the other side objects. I also asked, how do you determine the appropriate length of a postponement based on the nature of the offense? The judge told me that they consider how complex a case is, and they gave me a series of great examples. For instance, wiretapping cases. It could be anywhere from 30 to 60 days of telephone calls that will last for hours, so it can take years to analyze those calls. Also, if experts are involved, it can be extremely difficult to get everybody on the same wavelength in terms of scheduling. Also, witnesses. They may be moving or on vacation or even sick. Also, DNA analysis. We do not have a DNA lab here in Howard County at our disposal to send the DNA to, so we have to send it to Virginia, which takes time. I then interviewed a court administrator. The first question I asked was, what case management techniques do they use to bring cases before the court within the case time standard? And there are several different ways that they manage these cases. For instance, DCM plans, which is differentiate case management plans, which tells people how a case is moving through. They also use case managers, and there are different case managers for criminal cases, family cases, and juvenile cases. So basically, every type of case you could possibly imagine. They also use a calendar. I know that there's a master calendar and a hybrid calendar. And they have case assessments, so they analyze things for the future. I also asked, do you review with the administrative judge the performance of the court? And if so, how are adjustments decided? The court administrator told me that they meet with manager staff, court administrators, calendar management, Mr. Roby and Ms. Leibno. They brainstorm and come up with ideas, and after they do that, they bring it to the administrative judge with recommendations. He will then take it to the DCM committee, and then they will send it to the state, and the state will approve, edit, add ideas, etc. The third person I interviewed was a public defender. I first asked this person, what are the most common reasons you would request a postponement? The public defender told me that they may need to get more evidence, items that they do not yet have. They may need to do more work, for instance, more investigation, or they may encounter some discovery, and they might have a problem with scheduling with experts. As I said before, dealing with expert schedules and then your own schedule and other witnesses' schedules is difficult. They also may need to request more stuff from the state. I also asked this person, does their caseload ever impede their ability to ensure the defendants they represent a speedy trial? The public defender assured me that he's never had a problem requesting past Hicks because of that. He never goes, oh, I have too many cases, this is too much. And a strategy of his is that he doesn't schedule things too close to Hicks. He allows himself wiggle room. He said that this has happened to other people and it probably will happen again, but it's not that big of a deal because it doesn't happen often. The fourth person I interviewed was a private defense attorney. The first question I asked was, what are the most common reasons you would request a postponement? The private defense attorney told me that conflicts with scheduling, such as conflicts with the attorney, the client, or other witnesses, may affect the reasons why they would request a postponement, or preparing for a case, such as discovery from the state, discovery in general, or just further investigation to prepare an argument in front of the court. Also, weird occurrences such as illnesses or trauma may also affect the reasons why the private defense attorney would request a postponement. The second question I asked was, do speedy trial concerns impact your decision on whether or not to take on a defendant? And I asked this question because private defense attorneys are allowed to choose who they want to take on, unlike public defenders who have to take on everyone. And the private defense attorney told me that he very rarely decides to reject a case just because of how close it is to Hicks. However, he does consider how close it is, but it ultimately will not prevent him from taking on a case. The last person I interviewed was the prosecutor. The first question I asked was, what are the most common reasons you would request a postponement? Similar to what I've asked everyone else. The prosecutor told me an answer along the same lines. She said witness unavailability, and she also judges the importance of witnesses. So maybe an expert witness, maybe the most prevalent witness. She judges the importance of witnesses and determines which ones will go first and which ones will go last. The order is not predictable. It's set. She also said the same thing as the judge, that the DNA, since you have to send the DNA to the lab in Virginia, that takes a while, so she may have to wait for that and ask for a postponement, and along with any other scientific tests. I also asked, why does it benefit the state's attorney to bring a defendant to trial quickly? She first said that the longer it takes, the more difficult it is to find witnesses, and that memories fade for their witnesses, which will decrease their case, and it is the burden of the state to prove their case, and that sometimes justice delayed is beneficial for the defendant because of witness memories fading, but it's not beneficial for the state's case. There was one question that I asked every single person I interviewed, and they all gave me the same answer. I asked that the case time standard for criminal cases in Maryland, which is 160 days, I asked, in their view, is that a fair amount of time to try a case? And every single person, all 5 individuals who work within the Maryland judiciary, said yes. The 6-month case time standard is a reasonable amount of time to try a case. And I guess that accounts for why only 20 of the cases went over for the case time standard last year. My own previous thought was that maybe 6 months wasn't a fair amount of time to try a case. That was when I first started here and when I didn't know anything. But now that I've been at my internship for a long time, and now that I spoke to these individuals, and now that I just know more in general about the Maryland judiciary, I would say that the Maryland judiciary is doing a great job at ensuring the defendant's right to a speedy trial. I guess 180 days or 6 months is a fair amount of time to try a case, and the judiciary and the court administrators and everyone involved in these cases are doing a wonderful job at maintaining this. Thank you.